17 page for expunge criminal record. Expunge criminal record is starting on page 13, but 17 is just explanation first. Yeah, 17, after that, we go back to 13. Expunge criminal record. Disclaimer. This packet is intended general information only to guide you to filing over own expungements. Your situation may have factors requiring different procedure or forms. If you need further assistance, you may want to hire a probate attorney. Background check. You should disclose the conviction and the expungement in this situation. If you're applying for a government issue license, certificate, or permit, you must disclose your conviction and expungement. How does an expungement after strike or other sanction? Although your conviction may be dismissed, the sanction, such as firearms prohibition, exclusion, although your conviction may be dismissed, the sanction, such as firearms prohibition, exclusion after jury duty or strike cannot be dismissed. These remain intact for life. Expungement does not remove the conviction from your criminal history. California and FBI criminal history record will still show the conviction and the consequent dismissal. Reinstate your right to possess firearms. Allow you to omit the conviction from application for government issue license. See the court case firearm public inspection. The court file remains public record. Prevent the conviction from being used prior for a sentencing enhancement in subsequent convictions. Prevent the conviction from being used to impeach your testimony if you are called as a witness in court. Prevent the conviction from being used to confuse or revoke a government license or permit, such as real estate license, teaching credential, security guard certificate act. Prevent the conviction from being used by U.S. citizens as naturalization service for removal or exclusion purpose. If you want some criminal record left, going to the police and then just a driver license to show him, I need my criminal record. They give them right away criminal record. And then after that, we request for the expunge meaning elimination criminal record. after his sentence is over, and then after the probation is over, and then after the payment of the fine, after that you can request release my recording. If not release your criminal record, you cannot apply for the green card. You cannot apply citizenship, and then also you cannot apply any job. But in expunge criminal record, that's so easy. That's the recording. After that, you can do everything. Apply for the green card, apply for the citizenship. Everything is applied. And are you eligible for a dismissal? Eligible for a dismissal? You are eligible for dismissal of a conviction, and the court will dismiss your conviction if you receive the probation for the conviction and you successfully complete probation or obtain early release. 2, you also have paid all the fine, restitution, and reimbursement ordered by the court as part of your sentence. 3, you are not currently serving another sentence or on probation for another offense. And 4, you are not currently charged with another offense. Next, you never received probation, and 1, your conviction was a dismissal. 2, it has been at least 1 year since the date you were convicted. 3, you have complied fully with the sentence of the court. 4, you are not currently serving another sentence. 5, you are not currently charged with another sentence. And next page 18. Expunge criminal record step by step. Number 6, you have obeyed the law and lived in an honest and upright life since the time of your conviction. You are eligible for a dismissal, and the court has the discretion to grant you that dismissal if you received the probation, but you did not get an early release, did not fulfill all the conditions of probation, or were convicted of any offense listed in Vehicle Code 128102. But number 1, you have paid all the fine, restitution, and reimbursement ordered by the court as part of the sentence. And number 2, you are not currently charged with on probation for or serving a sentence on any other offense. Some convictions are not eligible for dismissal, are not eligible for. If you were convicted for any of the following sentence offense, you are not eligible for dismissal. On the Penal Code section 1203.4a, any dismissal misdemeanor and misdemeanor with the probation of Vehicle Code Section 3200, any violation of Penal Code Section 286, 288, 288C, 288.5 or 289J, a felony under Penal Code Section and infraction, expungement eligible charge situation, and then that's the eligible charge. Before that, even anybody can apply for the expunge, but forever cannot apply for the expunge. Forever cannot apply expunge. Any involved sexual harassment, any sex offense that's recorded cannot record, cannot release. That's so important. And then drinking drive, if first time after 5 years applying for the expunge, even 1 year sentence, after 5 years expunge, request for the expunge. Second time, in case penal code, that's the drinking drive is the second time, even he got judgment 2 years after 7 years request for, I'm sorry. First time expunge, the drinking drive after 7 years request for expunge. Second time after 15 years request for expunge. That's so high. Meaning for drinking drive first time after 5 years or 7 years request for expunge and request for applying for the green card on citizenship. But second time he got it in case after 15 years he can apply for the green card and citizenship. That's so high. And then involve the sexual, that's forever request, do not request for the expunge criminal record. Meaning he cannot apply for the his family, and then he is do not request for the green card, and then do not request for the citizenship. That's too high. Okay, page 18, expungement eligibility chart. Situation. You were convicted of a misdemeanor and are still on probation. You may be able to request early release from probation and file petition to have conviction dismissed. How to do it? File a PC 1203.3 petition to have probation termination early, and PC 1203.4 petition for expungement. Next one, you were convicted of a misdemeanor, and have successfully complete probation. File petition to have a conviction dismissed. 5. PC 1203.4 petition for expungement. Third, you were convicted of a misdemeanor and were never given any probation at all. 5. Petition to have a conviction dismissed. PC 1203 for a petition for expungement. You were convicted of a felony and are still on probation. Request early release from probation and file the petition to have a conviction. Request to misdemeanor and dismissed. 5 PC 1203.3 petition to have probation terminate early. 5 PC 17A petition to get felony reduced. And PC 1203.4 petition for expungement. That the felonies cannot apply for expungement. And then, if you're getting for the felony recording, applying for reduced to the misdemeanor, and then that's to prove misdemeanor. After that, request for expunge, and meaning felony is 2 times recording. Any misdemeanor is just 1 time recording, but the expungement for felony request for 2 times. First time reduced misdemeanor, second time reduced for the expungement. Next, you were convicted of a felony and are done with probation and or county jail time. File petition to have a conviction reduced and dismissed. File a PC 17 petition to get felony reduced, and PC 1203.4 petition for expungement. First time file a PC 17 petition to get felony reduced. Get felony reduced meaning for the misdemeanor. After that, reduced, and then PC 1203 felony for expungement. The 2 times should do. Next, you were convicted of a felony and are done with the probation and the county jail time. We did. Next one, you were convicted for a felony and were never given any probation at all and were sentenced to county jail. File a petition to have a felony reduced for a misdemeanor and file petition to have a conviction dismissed. File a PC 17B petition to get felony reduced and PC 1203 for a petition for expungement. Second time after that, expungement. Last one, you were convicted of a felony and were sentenced to state prison or under the authority of the Department of Corrections and Rehabilitation. File a petition for certificate of rehabilitation and pardon. see requirement about this process and 10-year rules on the certificate of rehabilitation and pardon. Yeah. We should go back to paper number number 13, page 13. Go back, page 13. Petition for dismissal. This just one page. First one and second one. You can handle by yourself. If you have any recording, criminal recording in California, you get this paper, just this paper, before making recording of this paper, go to police office. You arrest in the police office. I need a criminal record, my criminal record, and that day, they right away, they give the one petition. And then the petition, see that the petition, recording, and then petition for dismissal. You put right down. First line, attorney or party without attorney. Attorney is yes, or not attorney is okay. Name, phone name, street address, city, state, something, telephone number, email address, attorney for, 본인 스스로, I do by myself, in case his name on improper, P-R-O, P-E-R, improper. People of the state of California. People of the state of California meaning for district attorney. And defendant is me, date of birth, and petition for dismissal. And bottom, right side is court, they put right down. On date, date is court. The petitioner, defendant in the above entitled criminal action was convicted of a violation of the following sentence, following offense. And then it's meaning first line is the date. Date is a court date. What date I receiving that the any action, court date, offense, or was granted of deferred entry of judgment for the following offense. Code. That one is the if you receiving the criminal record from the police office, that's the code number here there. Code section, type of offense, felony, misdemeanor, or infraction, normally misdemeanor. If felony, put right down the felony, and then he applying for 2 times, normally misdemeanor, 1 time is the release. Eligible for reduction to misdemeanor under penal code. Yeah. That one is also police record they have. Eligible for reduction to infraction under penal code. Yeah, which one? Which the one you receiving from the court. If additional space you need not to 5 of them. More than that, almost impossible. Number 2, felony or misdemeanor with probation granted. Here, marked here. Probation was granted on the term and condition stated in the docket of the above entitled court. The petition is not serving a sentence for any offense, nor on probation for any offense, nor on the charge of commission of any crime, and the petition has fulfilled the condition of probation for the entitled period thereof. Mark here. Probation entitled period of the past. Number B, has been discharged from probation prior to the termination of the prior period thereof. That's the special case. Probation is not finished, but there are some special the period termination of the period thereof. C, should be granted relief in the interest of justice. Please note, you must explain why granting a dismissal would be the information interest of justice. You may complete and attach the discretion or submit other relevant document. Just to number 8 mark has fulfilled the condition for probation. 3, misdemeanor or interlection with the sentence other than probation. Probation was not granted. More than 1 year has elapsed since the date of pronouncement of judgment. Petition has complete with the sentence of the court and is not serving a sentence for any offense or on the charge of this commission of any crime, and the petition. 8, has lived an honest and upright life since the pronouncement of judgment and conform and obey the law of the land. Mark 8. These should be granted relief in the interest of justice. Please note, you must explain why granting a dismissal would be the interest of justice. You may complete and attach the attached declaration. Number 3 is just 8, mark 8. Next page. Just the back page, just one page. Number 4, misdemeanor conviction under Penal Code Section 647B. The petitioner has completed a term of probation for a conviction under Penal Code Section. The petitioner should be granted relief because the petitioner has established by clear and convincing evidence that the conviction was the result of his or her status as a victim of human trafficking. That's the number 4 is mark. Number 5, felony county jail sentence under Penal Code Section. The petitioner is not under suspension under Penal Code Section 1170H and not serving a sentence 4 on probation 4 or charged with the commission of the offense and should be granted relief in the interest of justice. And A. More than 1 year has elapsed since petition complete the felony's county jail sentence with a period of mandatory suspension imposed under penal code section. More than 2 years have elapsed since petitioner complete the felony county jail sentence without a period of mandatory suspension, supervision imposed under penal code section 1170. That's the misdemeanor, it's not marked. This section just passed. If regarding felony is marked here, 5, A or B. More than 1 year, A. More than 2 years, B. Petitioner requested that the eligible felony offense list above be reduced to misdemeanor. One more time. Petitioner requests that the eligible felony offense listed above reduced to misdemeanor, penal code section 17, and eligible misdemeanor offense be reduced to infraction under penal code section. Petitioner requests that he or she be withdraw the plea of guilty, or that the verdict or finance or guilt be set aside, and the plea of not guilty be entered and be the court dismissed section under section. First one, request for filed felony and reduced the misdemeanor. I declare on the penalty of perjury under the laws of the state of California that the following is true and correct. Excused today, date, signature of petitioner or attorney, signature, and address, city, something. This is expunged. Expunged is so important. If you live in the United States, some fight or some involved for any criminal recording, and then criminal recording is, if not expunged, you cannot apply for forever to green card. If you want to apply for the green card, you should do expunge first. You should remember, I need an expunge. Okay, and the next page, 15. Same thing, order of full dismissal. Number 1, the court denied the petition. That's applying for the first page and this page. And then court is made for the judgment. Number 1, the court denied the petition. Deny the petition, you should apply one more time, next time. Second, the court grants the petition. The court find from the record on file in this case and from the foregoing petition that the defendant is eligible for the relief requested. If court is marked here, that petition is approved, granted. Number 3, A, court reduced the felony offense to misdemeanor. Court, this one is also, if you apply for the felony marked here, the court reduced the felony offense to a misdemeanor. That's good. And then one more time you apply for the the misdemeanor, and please release recording. Second time, you can do it. B. The court denied the request to reduce the felony offense to a misdemeanor. That one is should apply one more time. 4. It is ordered that the plea, verdict, or finding of guilty in the above entitled action be set aside and vacate, and the plea of not guilty be entered, and then the complaint be and is hereby dismissed. Number 5. If this order is granted under the provision of a Penal Code section 12034, 8. The defendant is required to be disclose the above conviction in response to any direct question contained in any questionnaire, or number 8, the defendant is required to disclose the above conviction in response to any directed question contained in this questionnaire. Applying application for public offense or for licensure by any state or locally casted local agencies for contracting with the California state. B. Dismissal of the conviction does not permit a person prohibited from the holding a public office as a result of the conviction to hold public office. C. The defendant may also be eligible to obtain a certificate or rehabilitation and pardon under the provision set forth in Penal Code section 485201, Esquire. Six. If the order is granted under the provision of either Penal Code section 1203.4 or 12034A, defendant released from all penalties and disabilities resulting from the offense, excepting as provided of Penal Code section 12021 and 12021.1 and Penal Code section 13555. The dismissal does not permit person to own, possess, have in his or her control of firearm if prevent by Penal Code section 12021, 12021.1. 7. In addition, 6 meaning for the if not permit this expunging. After that, you cannot keep any arms, firearms, knife, gun, everything. 7. In addition, as required by Penal Code section 299, relief under Penal Code section 17, 1203.4 or 12034A does not release defendant from the separate administrative duty to provide specimen, sample, or print impression under DNA and forensic identification, database and data bank X. If the defendant was found guilty of trial of fact, not guilty by reason of insanity, please no contest to a qualifying offense as defined in Penal Code Section 296. Judicial officer, judge should sign here is the court grant any petition. And meaning for the you can apply for the expunge of criminal code. That one, the 3-page CR 180 and the CR 181. 181 is just nothing, just name only, your name only. Defendant information, first top, driver's license, social security number, task, you don't need that everything, just last 4 digit only, date of birth. That's one. Defendant information, and anyone is nothing. Court is made. And the next page. If this order is granted under the provision of Penal Code Section, the petitioner is required to disclose the above conviction is response to any direct petition contained in any questionnaire or application for public office or for license by any state or local agency for contracting with the California State Lottery Commission. B. Dismissal of the conviction does not automatically relieve a petition from the requirement to register as a sex offender. B is meaning dismissal of the conviction does not automatically relieve petitioner from the requirement to register as a sex offender. Any sex offender can apply for the expunge. 7. If the order is granted under the provision of Penal Code Section 1203.49, the Department of Justice is hereby notified that the petitioner was a victim of human trafficking when he or she committed the crime, and the relief order. Number 8. If the order is granted under the provision of Penal Code Section 1203.4, 1203.48, 1203.41, or 1203.49, the petitioner is released from all penalties and disabilities resulting from the offense, excepting as provided in Penal Code Section 29800 and 29900, for Section 12021 and 12021.1, and Vehicle Code Section 13555 in any subsequent prosecution of the petitioner for any other offense. The prior conviction may be placed and provided and shall have the sum of effect as if probation and not being granted or accusation or information dismissed. The dismissal code does not permit a person to own, possess, or have in his or her control firearms if prevented by Penal Code Section 19800 or 29900, formally Section 12021 and 12021.1. Dismissal of a conviction does not permit a person prohibited from holding public office as a result of that conviction to hold public office. 9. In addition, as required as Penal Code Section 299, relief under Penal Code Section 17b, 17de, 12024, 12034a, 12034.1, or 1203.49 does not release petitioner from the separate administrative duty to provide specimens, samples, or print impression on the DNA and forensic identification disabilities and data bank action. Penal Code 295 Esquire. If petitioner was found guilty by a trier of fact, not guilty of by release by the incentive, pleading no contest to a qualifying offense of defined Penal Code section, judicial officer sign. This one is this 3-page expungee request form, and then criminal code is released. That's so important. If you have a criminal code, you cannot apply for the green card, you cannot apply citizen, everything is cannot. Okay, 5-minute break. Okay, if not, we go. And then to finish this so early. Next page is State of California Secretary of State. Declaration of Domestic Partnership. Domestic partnership meaning not married, but we live all together. We live all together, not married. In this recording, just Secretary of State, domestic partnership recording, the same right, you are married. If you separate and that time you applying for the spousal support, everything. Declaration of domestic partnership. Important, read the instruction before completing this form. We are undersigned do declare that we meet the requirement of Family Code Section 297, which are as follows. Neither person is married to someone else. That's important. Neither person, both of us, neither person is married to someone else or is a member of another domestic partnership with someone else that has not been terminated, dissolved, or adjudged a nullity. Next, the two persons are not related by blood in a way that would prevent them from being married to each other in this state. 3. Both persons are at least 18 years of age, or if one or both persons are under 18 years of age, certified copy of the court order granting permission of the underage person to establish domestic partnership is attached. Both persons are members of the same sex, or one or both of the persons is over 62 years of age, and one or both meet the eligible criteria under Title II Social Security Act as defined in United States Code. Title 42, Section 402 for old age insurance benefit, or Title 416 of the Social Security Act as defined in the United States Code, Title 42, Section 1381 for aged individual. If the age is over 65, if not over the 65, any disabled, any hurt body, in case request for Social Security, SSI, Social Security, but domestic partnership applying, the other party can receive Social Security also. Next one, both persons content to the jurisdiction of the Superior Court of California for the purpose of proceeding or obtain judgment of dissolution or nullity of the domestic partnership, or for legal separation of partners in the domestic partnership, or for any other proceeding related to the partner's right and obligation, even if one or both partners cease to be a resident of or to maintain a domicile in this state. The representations are true and correct and contains no material omission of fact to the best of our knowledge and belief, violent intentionally, and materiality false declaration of domestic partnership shall be punishable as misdemeanor. Partner 1, partner B, 2, meaning husband and wife, but they are not married, just not husband and wife, just a domestic partnership. Partner 1, partner B, printed name, that's the first middle, signature of partner, optional, name change, new last name, new middle name, date of birth. They won't, even they are living for the domestic partnership, they cannot change the name. Partner 2 also, same thing, print the name first middle, signature of partners in the state of above, option, name change, new last name, new middle name, date of birth. They cannot change the name. If one wants to change the name, request for domestic partnership, mailing address, something. Next page. For earlier completion, this form is available on the Secretary of State website, something like that, www.sos.ca.gov, registers domestic partners registry. It can be reviewed, filed, and printed from your computer. If you do not complete this form online, please type of eligible printed B, black and blue ink. And the statutory filing provision are found on California Family Code Section 297 and 298. All statutory references are to the California Family Code unless otherwise stated. Complete the Declaration of Domestic Partners as follows. First one, both persons must meet all the requirements of Section 297 as stated on the front of the Declaration of Domestic Partnership. From both persons must sign and affix their signature to the same Declaration of Domestic Partnership. From third, both partners must print that name legibly. The name must be printed in the order requested: last name, first name, middle name. If there is suffix, example, junior, senior, it include this partner as of the last name. Even that the domestic partnership also, everything is the same thing, the marriage, they can change for the name. And then, one or both persons as a registered domestic partnership may change the middle or last name by which that person wishes to be known after registration of the domestic partnership by entering the new name and including their date of birth in spaces provided on the Declaration Domestic Partnership form. A person may adopt any of the following middle or last name. The current last name of the other domestic partners, the last name of either domestic partner given at birth, the name combining into a single last name, or a segment of the current last name, or the last name of either domestic partners given at birth, or hyphenated combination of last name. A complete mailing address is required. Address, city, state, zip code, printed eligible. Do not abbreviate city name. B. Next one. The signature of a birth person must be notarized with a certificate of acknowledgement. The Declaration of Domestic Partnership must be signed using the name of the individual prior to the name change, if any, listed on the form. The complete form can be mailed to Secretary of State, Domestic Partners Registry, P.O. Box something. Next one. Fee. The fee for filing from NPSF-DP1 is $10. For same-sex partners, as additional $23 fee must be paid at the time filing fee for a total of $33. Normally, anybody, the filing fee is $10, but the same-sex partner is $33. There is an additional $15 special handling fee for proceeding a document delivered in person to the Sacramento office or to the Los Angeles regional office. Payment for document for submit. by mail to Sacramento can be made by check or money order. Over the count in Sacramento can be made by check, money order, cash, or credit card. Next one, over the counter in the Los Angeles regional office can be made by check, money order, credit card. The Los Angeles regional office is not able to accept cash. Check or money order should be made payable to the Secretary of State. The additional $23 fee will be used to develop and support training circumspecific lesbian, gay, bisexual, and transgender domestic abuse support service provider who serve that community is regard to domestic violence, and to provide purchase specific to lesbian, gay, bisexual, and transgender domestic abuse. Brochure developed by the State Department of Public Health will be available upon request from the Secretary of State as funding allows. $23. That's the next one. Where to file this appeal? Number one, choose one of the boxes. I'm filing an appeal from the decision of a DHS officer. Example, visa petition, I-130 decision, name of beneficiary, name if any beneficiary, petition for name. I'm filing different type of appeals from a decision of DHS officer. Find the decision, something. First one is mark. 2, I hereby appeal to the Board of Immigration Appeals from the decision on somebody issued by some date. Specific reason for this appeal is continue a separate seat if necessary. Please refer to number 2 for further guidance. Warning. If the factual or legal base for the appeal is not. Number 4, do you desire oral argument before the Board of Immigration Appeal? 5, do you intend for a file separate written belief statement after filing this notice of appeal? Something. Okay, that one. General instruction, that's the next day. Today is finished. You came at this time.
The traffic.